subject to payment of liquidated damages of 48 lakhs.
44.19.
44 lakhs 19,000.
44.19 lakhs. The petitioner has sought to assail the aforementioned.
Here also, debarment for indefinite period.
और चला जाएगा. Daffodils लाए हैं?
जो हमने उसके पहले ही सब इतना जजमेंट लिखा दिया गया कि अब क्या कुलजा इंडस्ट्रीज
Daffodils लाएंगे तो उसी में है टेन्योर का, टर्म का.
और जो कुलजा इंडस्ट्रीज में भी है पैराग्राफ 25 में प्रोपोर्शनैलिटी. लेकिन
प्रोपोर्शनैलिटी की बात आप नहीं कर रहे हैं. अभी आप कह रहे हैं फॉर इनडिटर्मिनेट पीरियड. वो डैफोडिल्स में डिसाइड किया
लेते आएंगे तब.
The judgment authored by Honourable Justice Naveen Sinha, sitting with Justice Narayan. Right? It says from 3 to 5 years. That's the maximum.
Here, that is my lord, annexure 15 at page 120.
Annexure 15.
Page 120. यहाँ the site offered, Lord, first.
क्या है? Tell us what is the matter.
Lord, what happened, Lord? The contract was for single Gram Panchayat habitation piped water supply. The agreement was executed on 15th July 2019, and the
one second, sir. One second. So therefore, are you pressing all the points? Number one, debarment. Number two, removal of liquidated damages. Then you are asking the court to pass an order directing for payments.
Debarment.
You have to limit your press.
Debarment.
आप debarment करिए, liquidated damages करिए. Those are cognate matters. We are not passing any order with respect to payment of bills. If that debarment order goes, you can press it. All right, for grant of reasonable time extension, this also we can't. All right, direction of respondents to make payment of penal interest.
यही दो debarment चला जाए, liquidated.
Now let us see. Now these two prayers, in the context of these two prayers, he is saying something to you. He is saying something to you. Take his instruction.
ठीक है, हुजूर हम सीधे कह देते हैं कि although agreement was executed on 15 July, on 22/11/2019, that is annexure 6 at page 103, the site was changed. Site ही suitable नहीं था, they themselves changed the site, and that is apparent from annexure 6 at page 103.
एक मिनट पहले हमें देखने दीजिए, what was this project?
Piped water supply.
13 single Gram Panchayat habitation piped water supply schemes. Now the site was changed when?
Not the site, annexure 6, if my
No,
lord.
वो ठीक है, डेट बताइए ना.
जी. Which is 22/11/2019.
22/11/2019. And you are asking for a change of the site on 30/8/2009.
Even prior to that, there was a meeting already. The site was not suitable.
So still 3/10/2019, you were waiting for a new site, you were clamoring for it, and it was shortly done thereafter, about a month later.
Even on 10th October, we requested that after meeting.
So there was a delay with the change of site. Change of site was necessary for you to continue. देखिए दो चीजें आपने पिटीशन में बहुत सारी बात लिख दी है, उससे गड़बड़ हो जाएगा. Change of site was necessary for you to start working.
Yes, Lord.
Therefore, change of site cannot be cited as a ground for non-performance. You have to say that delayed change of site was one which halted.
Obliged, my lord. Delayed change of site हो गया. उसके बाद
एक सेकंड और देखिए.
Design was approved finally on 20th March 2020.
20th of March 2020.
That is annexure 8 at page 105.
And you had given it in right time.
Yes. Okay.
No, it took only a month for its approval. Only a month. All right? And thereafter lockdown.
20 March को हुआ और lockdown immediately thereafter from 25th March 2020. National lockdown we have stated in paragraph 13 at page 10.
Time extension.
So accordingly, prayer was made for extension, and they sat over the matter and they granted extension up to 31st March on 17th February 2021. Kindly see annexure 10, page 107.
Now let us now read the order of department.
Annexure 15.
Annexure 15, page 120.
120.
और 31/3 तक extend किया. I could not have worked as per departmental circulars because no payment would be made if I had, without extension, if I had carried on work. Those documents are there.
120. No. We'll take the dates again, but अभी हमें order दिखाना है.
6/4/2021 order, annexure 15.
पढ़िए.
पूरा है. जल जीवन मिशन योजना अंतर्गत एजेंसी एकता एंटरप्राइजेज बसंत विहार सोनसो बेतिया से एकरारनामा संख्या सोनसो के बाद जी परंतु विभिन्न कारण उन्होंने कार्यादेश हुआ 15 यत्ना को एकाकृत कार्य पूरा होने की तिथि 14 जून 20 थी, किंतु विभिन्न कारणों से दिनांक
डेट बताइए. 14/6 है, 14/8 है.
14/6 है, क्योंकि ओरिजिनल एग्रीमेंट 11 मंथ्स का था.
ठीक है, तो
14/6 परंतु विभिन्न कारणों से दिनांक 14 जून 20 तक जलापूर्ति योजना के किसी भी अवयव पर निर्माण कार्य प्रारंभ नहीं किया गया. फलतः विभागीय निविदा समिति की आहूत बैठक दिनांक 17 फरवरी 2021 को सभी पहलुओं पर सम्यक विचार उपरांत 31 मार्च 33 डेज का इफेक्टिव तक दंड रहित विदाउट एनी imposition of any fine
extension of time
समय वृद्धि प्रदान की गई. परंतु एजेंसी एकता एंटरप्राइजेज द्वारा योजना के मुख्य अवयव 2 उच्च प्रवाही नलकूप में से मात्र 1 उच्च प्रवाही नलकूप का निर्माण इस अवधि में किया गया. इस कार्यालय के पत्रांक स्वयं दिनांक 26/2/21, पत्रांक 242 डेटेड 16/10/20 एवं 561 डेटेड 24/3/21 द्वारा एकता एंटरप्राइजेस को जनहित से जुड़े कार्य को पूर्ण करने हेतु निर्देशित किया गया. साथ ही कार्य नहीं करने पर एकरारनामा के अनुसार यथोचित कार्रवाई करने की चेतावनी भी दी गई. एजेंसी द्वारा कार्य में अभिरुचि नहीं लिए जाने के कारण सहायक अभियंता लोक स्वास्थ्य अपर प्रमंडल नरकटियागंज के पत्रांक डेटेड 26/2/21 के द्वारा एजेंसी को डिबार करने की अनुशंसा भी की गई. एजेंसी द्वारा कारण परीक्षा पर उनके पत्रांक 26 दिनांक 23
इसकी नोटिस कहाँ है? इमीडिएटली प्रोसीडिंग दिस ऑर्डर, वेयर इज द नोटिस?
24/3 का उसके जस्ट पहले वाला चिट्ठी है, एनेक्चर 14 एट पेज 118, इनके काउंटर में भी यही है। इस पर वर्चुअली नोटिस,
ये नोटिस ठीक है
जी,
नोटिस से कोई दिक्कत
नोटिस में है कि तो पहले ही कह दिए हैं कि आप नहीं किए हैं, इसलिए ऐसा हम प्रस्ताव भेज रहे
नहीं,
हैं।
वो ठीक है,
कुछ नहीं,
वो ठीक है
जी,
उस पर आपकी बहस नहीं होगी
जी, नहीं।
आपकी इनडिटर्मिनेट पीरियड ऑफ डिबारमेंट उसी पर लिमिट करिए
जी,
बोलिए।
एवरीथिंग इज रिटन द ऑर्डर में, otherwise the काउंटर में वही है।
नहीं इनडेफिनेट पीरियड ऑफ डिबारमेंट जो कर दिया है उसके लिए
ये तो
डैफोडिल्स वाला केस
ये नहीं
आस्क माय
3 to 5 years।
कम हियर।
और दूसरा है कि जब उसके अंदर एक्सटेंशन पेंडिंग रखे हैं
डैफोडिल्स निकाल दो।
और सेकेंड एक्सटेंशन ग्रांट किया 44 लाख एन ऑड का दंड देते हैं। सेकेंड एक्सटेंशन, आफ्टर ऑल दिस दे फाउंड दैट reasons were justified for granting second extension also, but they have granted it after imposing penalty of 44 lakhs liquidated damages LD. That is annexure 33, which is the second.
But second extension has been granted subject to your making payment of liquidated damages.
So
where is that order?
Lord, annexure 23.
One 6 minute. No, sorry.
Page 136.
आपका लेटर
136.
वेट एरिया करते हैं which page?
Lord, if my lords will kindly find the page 144, annexure 26.
What is that?
Lord, annexure 26, page 144, relevant portion at page 145. This is the enclosure along with the letter annexure 26.
This calculation of liquidated damages.
Maximum LD value. So
उसके अलावा
second time, बस इसी में 44 lakhs and 19,000.
इससे नहीं आपका एक्सटेंशन कहाँ हुआ है subject to payment of this?
यही सेकेंड इसी में है कॉलम 7, सेकेंड टाइम एक्सटेंशन 31/3/2022 with LD with liquidated damages.
नहीं वो तो आपका वही जो फर्दर इसके बाद एक्सटेंशन नहीं किया है
जी, इसके बाद
ये फिर गलत हो गया ना जो आप नो दैट्स अ डिफरेंट मिस्टर शाही प्लीज नो पहला देखिए एक मिनट पहले आपको उस ऑर्डर पर आइए जो आपने जिससे डिपार्टमेंट हुआ है जी इसमें 31/3/2001 तक दंड रहित समय वृद्धि प्रदान की गई थी
विदाउट लिक्विडेटेड डैमेजेस।
और ये फिर यहाँ पर लिक्विडेटेड डैमेजेस कर दिया।
उसके बाद एक्सटेंड किया है 31/3/22 तक विद लिक्विडेटेड डैमेजेस ऑफ 40।
ये कब था? 21 तक था
जी,
ये 21 तक था और 1 साल का फिर बढ़ाया है। फिर उस पर तो काम ही नहीं किया होगा आपने।
काम तो हम कुछ कर रहे हैं।
इसमें आप कैसे काम करते हो? पेमेंट करने के बाद दैट वाज कंडीशन प्रेसिडेंट
कंडीशन प्रेसिडेंट
वो तो सब्जेक्ट होगा वी डोंट नो। We don't know. Indeterminate period के लिए हम इसको set aside करते हैं. Take a decision afresh.
और हुजूर लिक्विडेटेड डैमेजेस के लिए भी तो
No, that condition again. Whether it is required. Liquidated damage तब है जब extension के लिए किया. उस समय तो दंड रहित था.
जी
अब आप उस पर बहस करिए ना जब
लिक्विडेटेड.
Question is that liquidated damages 31/3 तक ही काम खत्म हो गया आपका.
31/3 तक हो गया हमारा एक्सटेंशन. उसके बाद वो लोग कंसिडर करते रहे. जब कमिटी ने रिकमेंड किया तो हमको कम्युनिकेशन हुआ.
ये बहस करिएगा जब हम आपकी डिपार्टमेंट कंप्लीट हटाएंगे, वहां फिर से डिसीजन लेंगे, उसी समय ये लिखेंगे कि लिक्विडेटेड डैमेजेस के बारे में भी देखिए.
हाँ फिर देख लें.
लिखिए. थर्ड मिस्टर पुष्प. यस
डिपार्टमेंट अगर रीअसेस कर ले उसके बारे में भी तो
Let us see how it comes up. Heard Mr. P. N. Shahil and Senior Advocate for the petitioner and Mr. Upendra Pratap Singh for the state.
डिपार्टमेंट तक डिपार्टमेंट को क्यों कंसिडर करना.
देखते हैं. The petitioner, a proprietorship concern, whose proprietor has approached this court against the order dated 6/4/2021 passed by the executive engineer PhD Bethia, whereby the petitioner has been debarred for an indeterminate period from entering into any agreement with any department of the government. Mr. Shahil and Senior Advocate appearing for the petitioner. While assailing the order, lays primary emphasis on the limitless in period of time, order of debarment, which is not in tune with the law relating to blacklisting and debarments. The petitioner was selected as a concessionaire by the PhD West Champaran for carrying out the project of single gram panchayat, for carrying out project of 13 single gram panchayat / habitation piped water supply schemes (SGS/SHS) in West Champaran in the district of Bihar. At a contract price of rupees 441.90 lakhs. It has been urged on behalf of the petitioner that though the Joint Director, State Project Management Unit, gave a green signal to the petitioner to proceed with the work at one place for it to be finished within a period of 11 months, the site so selected was found to be completely waterlogged low-lying area where tube well boring work could not have been carried out. This was promptly reported to the department though a survey and search for a new site was undertaken, but the site was changed only after a delay of 4 months, which was one of the major reasons for non-completion of the project in time. Shortly thereafter, national lockdown was imposed in view of the outbreak of COVID-19 pandemic, which continued from 25/3/2020 to 17/5/2020. This necessitated an extension of time for the petitioner to complete the work, which was though sought by the petitioner, but the department, for no good reason, delayed. The work therefore could not be started before the extension of time. Only on 17/2/2021, an extension of time was given to the petitioner.
Till 31st.
But that was only for 33 days, which reflected complete lack of application of mind. When the project had not even been begun, project had not even effectively begun, extending the time period by 33 days, Mr. Shahi argues, was most unreasonable and perhaps by a malicious intent to anyhow prevent the petitioner from completing the job for the department to terminate the contract. On notice to the petitioner for not having completed the contract on time, for future action of debarment, the petitioner, the petitioner replied to the same, explaining the above noted circumstances, but by order dated 6/4/2021, the termination, the contract was terminated. No, the contract was by 21. The petitioner was debarred, as noted above, for an indeterminate period in entering into any contract with any department of the government. Surprisingly, the order reflects that the extension till 17/2/2021 was given without liquidated damages, but after the order of debarment was passed, there was a further conditional extension of 1 year, subject to payment of liquidated damages of 48 lakhs.
44.19.
44 lakhs 19,000.
44.19 lakhs. The petitioner has sought to assail the aforenoted decisions, namely indeterminate debarment with all government departments, extension of the period, which also appears to have expired today, which also appears to have expired as on date, but only with liquidated damages of 44.19 lakhs. The grounds of assail are primarily the limitless debarment and not adverting to the reasonable and plausible explanation offered by the petitioner for delayed execution of project.
In fact, in paragraph 35 of the rejoinder, we have said that we have substantially completed the awarded work and only tank staging work remains. Respondents have paid 2,84,52,755 against total approved cost of 3,93 lakhs.
The lead counsel for the petitioner therefore submits that the order of debarment ought to be quashed, an opportunity be given to the petitioner to explain his cause afresh, and a direction be issued to the department to refer to the reply and then take a fresh decision with respect to further extension with or without liquidated damages, and making available new sites for carrying out the rest of the project. It has also been pointed out by the learned counsel for the petitioner that almost 90% of the work, despite such handicaps, has been done, for which payments also have been made by the department. After having heard the learned counsel for the parties, we find that the order of debarment is without any time period. The reasons assigned by the petitioner in defense of the charge of delaying the execution of a public project has not at all been adverted to, especially the reasons which are known, which are in the know of all and sundry, that because of the outbreak of pandemic, there was a lockdown with a very strict government regulation not to continue with such works where there would be congregation of people. An order of debarment is akin to blacklisting, which operates to the prejudice of a commercial person, not only in presente, but also in futuro, and it casts a taint, a slur, which is very difficult for such commercial entity to overcome. For all practical purposes, it causes civil death of such commercial person. The repercussions, there is a waterfall repercussion which need not be adumbrated. The sole purpose of insisting for a show cause notice with the proposed action and appraising / evaluating the response is that the decision could be tested with the lens of objectivity. From the order of debarment which has been challenged, which has been assailed in the present, which has been impugned in the present petition, we find that no good reasons have been assigned for discarding the explanation of the petitioner, and that the order is disproportionate as it debars the petitioner from entering into any commercial contract, any commercial venture with the government, with any department of the government. The Supreme Court in Pulja Industries Limited versus Chief General Manager, Western Telecom Project, Bharat Sanchar Nigam Limited and others, 2014, 14 SCC 731, and Wet India Pharmaceuticals Limited, and Wet India Pharmaceuticals Limited versus State of Uttar Pradesh and another. Citation deadline. Have held that an order of permanent debarment is absolutely unjustified. What has struck us instantly is that if the performance of the petitioner was so bad as to incur an order of permanent debarment with all government departments, how was it that a decision was taken to extend the time period further, though of course with payment of liquidated damages. Debarment and blacklisting are the harshest of all decisions against a commercial person, which is an incidence of last resort. If a conditional extension of time was given by the department, it presupposes that the lapse on the part of the petitioner was not of such a kind which warranted a decision of limitless debarment. Limitless debarment. For the reasons so noticed, we do not find the order of debarment to be justified in the eyes of law, and perforce we set it aside. Since the order of decision of extension of time is conditional, we are not passing any order with respect to that, as it would be open for the petitioner to accept such extension offer. However, we direct that a decision keeping in mind the above noted aspects be passed by the department afresh within a period of 30 days to be counted from the date of receipt of the production of a copy of the order before the department. So it would be more appropriate if the petitioner would be allowed to submit his cause for a further extension without liquidated damages, as the delay was on account of conditions which cannot be saddled on the petitioner, part of which was because of the national lockdown for major period of the tenure of term, for major period of the tenure of work. With the aforementioned direction, the writ petition stands disposed of.